Be ready. Now, I am going to dictate a judgment of MALDA District Court at the rate of 120 words per minute. Let's start. This appeal is preferred by the appellant assailing the judgment order of conviction and sentence dated April 27, 2009 and April 28, 2009 respectively, passed by the Larded Additional District and Sessions Judge, Fast Track, 5th Court, MALDA, in Sessions Trial number 71 12 of 2007, arising out of Sessions Case number 321 of 2007. By virtue of the impugned judgment and order, the appellant was found guilty of the offence punishable under Section 302/201 of IPC and convicted and sentenced to suffer rigorous imprisonment for life with a fine of rupees 2,000 in default, simple imprisonment for 2 months for committing an offence under Section 302 IPC. Additionally, the appellant was sentenced to suffer rigorous imprisonment for 7 years with a fine of rupees 1,000 in default, simple imprisonment for 1 month for the offence under Section 201 IPC. Both the offences were directed to run concurrently and the period of detention undergone was to be set off as per provisions of law. While the accused Vishwajit Das and Shivani Roy were acquitted under Section 235 (1) CRPC as found not guilty of the offence punishable under Section 302/201 of IPC. Stop para. On May 27, 2007 at about 6:30 a.m. PW1 Dijendranath Mondal received information about a beheaded dead body under the Asan Shahid Bridge. The dead body of an unknown person aged about 30 years was found with sharp-cut bleeding injuries on the throat and chest. The complaint was lodged and a case was initiated under Section 302 IPC. The prosecution's case relied on circumstantial evidence including the last seen theory, motive and recovery of the weapon of offences. Stop para. No eyewitness to the incident. Entire case based on circumstantial evidence, contradictions in statements of witnesses regarding last seen together theory, lack of corroboration for the alleged theft and or snatching of victims' belongings, inconsistencies in statements regarding the presence of witnesses and victims' activities on the previous day. Victims' consumption of liquor contradicts the postmortem report. Failure to establish motive for the murder. Doubtful seizure of weapon of offence and other articles. Contradictions in seizure witnesses' statements. Para. Last seen theory. No credible evidence supporting the last seen theory. Contradiction in witness statements and strained relations between victim and appellant undermine the claim. Theft, snatching allegations, inconsistencies in witnesses' statements, lack of corroboration from the GDE and contradictions regarding the nature of the theft or snatching. Alleged recovery of the articles. Doubts raised about the proper seizure and identification of recovered items including the weapon of offence. Motive. Prosecution failed to prove a motive for the murder. Blood group inconsistency. Victim's blood group does not match the blood on the weapon of offence. Para. Circumstantial evidence. Prosecution did not establish a complete and reliable chain of circumstances pointing to the guilt of the appellant. The appeal contends that the prosecution prosecution's case is based on weak and unreliable circumstantial evidence, the court is urged to consider the inconsistencies, contradictions, and lack of corroboration in the witness statements. The appellant asserts that the judgment order of conviction and sentence should be set aside due to the failure of the prosecution to establish a conclusive chain of circumstances leading to the guilt of the appellant. After a thorough analysis of the evidence and arguments presented, the court allows the appeal, setting aside the judgment and order of conviction and sentence dated April 27, 2009 and April 28, 2009. The court emphasizes the failure of the prosecution to establish a complete and reliable chain of circumstances linking the appellant to the crime. The decisions cited by the state are deemed distinguishable from the present case and the appellant is acquitted of all charges. The court orders the immediate dispatch of the judgment along with the lower court records to the trial court for information and necessary action. An urgent certified copy of this judgment is to be provided to the parties upon application. Stop. Thank you.